Okay, thanks for making it this far. I want to end this series of substantive videos by talking about a few more features of the criminal law in a free society that are kind of general background principles, kind of meta principles that don't directly relate to the harm principle or the desert constraint, which have been our main focus so far. There are three of them. There's the principle of evaluative neutrality, principle of free speech and association. You'll be familiar with that one. And then what I'm going to call the buffer zone principle. So the principle of evaluative neutrality basically says that the criminal law should not force people to live or demonstrate any commitment to one particular holistic, moral, or religious worldview, or holistic, moral, or religious vision of how life should be led, the good life. Instead, the substantive criminal law, the rules on the books about what we should do and what we shouldn't do, should permit people to pursue a wealth of different visions of the good life, as long as your behavior doesn't foreseeably harm or risk harm to other people in tangible ways. Right? The criminal law, substantively, its rules should be consistent with a range of different substantive views about what the good life is and how you should live. The criminal law should mark out the core of our common commitments about what is simply beyond the pale, what's too culpable to be tolerated in society. And so the criminal law should be neutral between substantive views of the good life and should be supportable regardless of, as much as possible, regardless of your substantive values, okay? Of course, the criminal law can and must commit to some evaluative principles. I'm not saying the criminal law can be completely evaluatively neutral, right? But these will generally be more likely to be abstract principles like justice, equality, fairness, individual freedom, individual dignity, those kinds of principles that can be accepted across a range of different substantive moral or religious viewpoints. The criminal law is supposed to be, as much as possible, ecumenical and neutral between the positive visions of how life should be led and what values to hold. It's an aspiration, and for that reason, a meta principle. But keep that one in mind as an important animating principle for what the criminal law should look like in a free society. Second, free speech and free association. Right? This is a familiar one from other contexts, so I won't spend too much time on it. The idea is that criminal law should not unduly restrict or deter free speech, even unpalatable or somewhat offensive speech, provided the speech doesn't directly threaten or endanger or harm others in tangible ways, where those tangible harms might be like physical or psychological harms or harms to property rights. Okay? Not mere hurt feelings. That's okay. We can tolerate that in a free society. Free association is similarly important. The criminal law should not unduly restrict or deter free association, hanging out with the people you want to hang out with, simply put, right? The criminal law should not unduly restrict free association, even if it's a loud group, a rowdy group, you're a bit provocative, right? Provided that the gathering doesn't directly threaten anybody, endanger anybody, or harm others in tangible ways, we can tolerate it. That's the kind of thing a free society can tolerate. A lot of good in life comes from being with other people, and the criminal law should not unduly burden our right to be with the people that we choose to be with. Principle number 3, buffer zone. The substantive criminal law, according to this principle, the substantive criminal law should be made without any assumptions about distinctions between good or bad groups of people. And importantly, in designing the criminal law for a free society, we always have to remember that any of us could find ourselves in the position of a defendant. Any of us could end up being wrongly suspected or accused of a crime, and that even the best system is fallible, and there's no 100% guarantee that there's never going to be a wrongful conviction. We know that statistically this is going to happen. Okay? So what that means is that we need a buffer from the criminal law. A way to operationalize this idea is that the criminal law should not kick in, according to the buffer zone principle. The criminal law should not kick in to regulate our conduct until the conduct meets some relatively high threshold of seriousness, of serious wrongdoing, or tangible harm. Only then is a criminal law response justified. Within the zone of conduct that doesn't raise a serious question about whether there's a high level of culpable wrongdoing, within that zone of no or only slight wrongdoing, we have to err on the side of protecting freedom and keep the criminal law well away. So we shouldn't criminalize only low-level misconduct, according to the buffer zone principle, right? Even if in some of those cases there actually will be some misconduct, the idea is that there's a buffer zone where if it's a matter of only slight wrongdoing, right? A little bit of dishonesty maybe, or a little bit of selfishness, but no real threat of harm to others, the criminal law should stay away. And that's because of this idea that the criminal law in a free society will be able to tolerate a little bit of low-level wrongdoing before the criminal law gets involved. And I'm calling that the buffer zone principle because to sort of highlight this idea that we all, because of our individual freedom, merit some degree of protection from criminal law intervention. Some degree of seriousness has to be met in your conduct before the criminal law can and should get involved. And that's just part of what it is to live in a free society. Beyond that, the criminal law should get involved. It should keep us safe. It should protect us, but only if the prerequisites of a fair criminal law, like the harm principle and the desert constraint, are clearly and convincingly satisfied.